They're playing more games and more games and more games and more games and more games. Welcome back to SouFLoTV again, everybody. It is your host with the most. This one is an update as to what has happened now with the Vybz Kartel appeal hearing, if there should be a retrial or not. Okay? Point blank, period. The judges have said that they will be handing down a decision by July 31st. Where does that leave us? That means July 31st, today is June 18th. From June 18th to July 31st, you have an entire month of 31 days in July, and then you have the rest of this month from the 18th to the end of the month. So you have 40 odd days, right, for them to come up with a decision. Now here's the thing. Anywhere from tomorrow the 19th all the way to the 31st on any given day, they can drop the decision on us, and it doesn't have to be a planned day, right? Now, I said this before. When we went live this morning, I said this can go up, down, left, or right? And I explained the up, down, left, or right. They could have been released on bail, which is still something to think about, because they are still incarcerated. They are still now just men who are accused but not convicted. And the state, while the state is arguing if there should be a retrial or not, and trying to get a retrial, they just sit in limbo, just being charged. And I've explained to the public already that many people have been charged with murder in Jamaica and are out on bail. So what is the difference with Vybz Kartel, Sean Storm, and the rest of the guys if they are charged like all the others who have been charged and are out on bail? They just simply do not want to grant them bail. They just simply want to drag this case along as long as they can drag this case along. You know when you squeeze orange, and you know say the orange sweet, I try squeeze out all the juice out of it. This is exactly how this case is going. They are wringing it for everything out of it. Every tip of juice have to come out of this case, you know. And it plays out well in media because a lot of people are now entertained. But at the end of the day, what is the decision going to be? This is the part where we jump in and we try to bring some clarification. So let's go through the law jargon first, and then we're going to talk about what the judge actually said today. Now, day 6, this is. First of all, the lead judge on this case previously told us that this case will not go past Friday. It must not, and it will not. And then it did. So it kind of leaves us in a place as to, okay, is this a judge that stands on her word? Is this a person that says something and does it? Pardon me if I'm wrong, but given my time that I spent in the U.S. military, I can tell you this. If it is said that Friday is the deadline, there is no excuse that is accepted. There is only repercussions for it not being the deadline. In other words, then, it is going to be the deadline, and everything dead on that line on that day. You know what I mean? I don't know any other way to express it. So I was kind of thrown off when the judge first said it will not go past Friday, it must not, and it will not, and then it did. And here we are on day 6. So defense counsel John Clark today raised concerns about the absence of some of the exhibits in the murder case of Vybz Kartel and his co-accused. This is what happened in court today on the last day before the judge said they will have until the 31st of July to come up with their decision and make it known. So John Clark now, during his response this morning to the Court of Appeal, to the 3-panel judges, to submission from the Crown, which is the DPP. The DPP, Department of Public Prosecution, which is seeking a retrial, they submitted some stuff to the judges, and John Clark is a part of the defense team, Vybz Kartel, them, Sean Storm, them side, so he now has to counter what was submitted. And John Clark, and they disclosed that the prosecution has only accounted for 16 pieces of evidence when based on the transcript of the trial, and there should have been 25 exhibits in total. So basically, all they're up there doing is trying to show the three judges. One side is trying to show the judge, we're ready for a retrial. The next side is trying to show the judge it's going to be a waste of time. They're not ready. So when the DPP side come up and say, yep, we're ready and we have these pieces of exhibits, the defense side came in and said, well, it was supposed to be 25 pieces from affidavits from what we know. So how come you're only accounting for 16 pieces now? Where is the other 8, 9 pieces? Among the evidence that is not re-verified is the signature of the main alleged or so-called or alleged eyewitness on his handwritten statement that was taken by the police. Among the evidence that is not re-verified is the signature of the main eyewitness on his handwritten statement that was taken by the police. I don't know how to re-verify that signature other than to go find that eyewitness and ask him again, is this your signature on this handwritten statement? Did you write this statement for yourself? Were you coerced in writing this statement? Were you pressured in writing this statement? Or is your statement truthful and you are still available to testify in a new trial and you are ready to stand on these words that's written on this paper? Did you sign off on this document? That's very important. And like the judge said before, we're not sending this case back for, knowing that you guys are over there running behind, running down witnesses, trying to find them and all that. And a list of names is not enough. We need to know that you are in touch with them. We need to know that they have expressed to you that they are ready and they are willing to participate, so on and so forth. You have a location for them, you can find them, etc. They don't want to send this case back for a retrial and then suddenly the problem becomes we can't find the people. Many cases have been thrown out in Jamaica because there was no witnesses there to testify when the time came. You understand? So the judges now at the 3-panel appeal level are saying, listen, line up the thing properly. And if we can't line up the thing properly, then we are not going to send it back for a retrial. Which would be a win for Vybz Kartel, because that would mean that Vybz Kartel, Sean Storm, and them, they would be acquitted altogether. Now, that is the final resting place of this case. After 13 years, this case would finally be put to rest completely for good. But it's a long journey getting to this place. So, on the face of the record before the court, it seems that there is an issue to be resolved because in Miss Lorna Green affidavit, after she indicated that she said as a result, I caused checks to be made of the file. Based on my review of the file, a total of 16 exhibits were tendered in the matter. I caused a search to be conducted of the secure area where the exhibits are stored, and it was found that only 16 exhibits are accounted for. So it is apparent of the affidavit on record that what the DPP has presented to us as the verification of all exhibits from Miss Green, that there is still some work to be done, is what John Clark said. They need to go and find the rest of the exhibits, because we know that it's 25. He explained that Supreme Court Registrar Lorna Green had indicated in her affidavit of verification that all exhibits in the matter were in a secured area, and that based on a request from the Director of Public Prosecutions, had made the necessary checks and certified that exhibits up to 16 were available, not 25. Consequently, he pointed out that the prosecution, in its argument about the strength of its case, must consider the exhibits which are accounted for. Continuing further on the matter of exhibits, Clark also raised concerns about a possible retrial on exhibits which have already been leaked to the public. Now, this is a very dangerous field. We agreed entirely, he said, with the Crown's submission, and mere adverse publicity is not enough for an adverse position. That's not enough to just throw out a case. But this is unique. And what we are concerned about is not the publicity. What we are concerned about is that their prejudice of such a degree in relation to the content, and that we are saying content is the jury tampering, linking, and the link between the accused men, he said, in addition to the leaked materials. Now, in the meantime, acting DPP Claudette Thompson, who is expected to argue that they want a retrial, Claudette Thompson, who is the person who took over from the lady who was before, who so many people do not like, Paula Llewellyn. Thompson, during earlier submission, had indicated that even without the technological material, which includes digital and communication evidence, the Crown would still have an objectively strong case with the direct evidence that it has, which is what they are going to say anyways, right? They're going to keep on saying, we have a strong case, give us a retrial. And it's their job to say that because that's what they're there for, right? Whoever agenda it is that they're running with, that's the storyline they're sticking to. The attorneys, the defense attorneys, their job is to show the Crown, not the Crown, but to show the appeal judges that there is no strong case. And it is unnecessary in many ways to go for a retrial. So her argument followed an indication from the defense that it would be challenging the use of some of the technological material if the matter is retried, which we know about that already, right? This is where they are saying we will bring in the independent forensic expert to go through this technological material that you are so heavily reliant upon. And let's not forget that this expert had already went through technological material and had deemed it to be tampered with. So, do you want to go there again? Because we still have the same expert who is willing to come into court to say, yes, I'll put my reputation on the line, my professional reputation on the line, to say that this was heavily tampered with. Now, let's move on to what the judge said today so everybody has a clear understanding of where this case is and what is going on. I'm telling you, don't be disappointed yet. They're dragging their feet, they're dragging it, but slow justice is better than no justice. Even though this is a case that was expedited and needs to be dealt with expeditiously, it still seems as if they are dragging the case more and more and doing it purposely to many, but understanding is required. So, the question of a retrial is never easy for a court of law, especially when it involves serious offenses and lengthy delays. It's going to take us time, but the court is mindful of the need for expedition in this matter. These are the words of the lead judge, Justice Marva MacDonald Bishop. That is what she said today. The court's judgment is reserved. Given the importance of the case, even if we reached a decision, we cannot come back to just give our decision without our reasons for that decision. And that is where the delay usually comes in. But we're mindful of all the issues and especially the health issue of one of the appellants. So, we'll do our best and we can say we aim for no later than the end of term. The end of term works out to be July 31st, which is a deadline day. The defense and the prosecution closed their arguments today. The hearing started June 10th and it ended on June 18th, minus the weekend because there was no court being kept during the weekends. So here are the words of the judge today. What the judge basically said today is this. Listen, it's hard to make a decision in this case. Basically, because if you all remember, this case took 64 days to try in court. Even at the Privy Council level, the Privy Council judges said that is a whopping case. And even in the UK that has all resources, finances and everything to foot a bill like that in this case, that's still a rough ride. That's a lot of days, time, resources, manpower put into this case, right? So don't expect like a decision in 5 minutes is what the judge is basically saying. So this morning when we went live, I said one of the scenarios that could happen is the defense and the prosecution will go at it again and they will eventually both close out all sides, all arguments. And if they do, and it takes up all day, then definitely there would not be a decision made today because the judges would then have to take into consideration what was said, what played out before them, the points that were made by the DPP who is seeking a retrial, and the points that were made by the other side, which is the defense, and then they have to weigh those up. And then they have to come up with a decision. So the judge is basically saying, listen, this is going to be rough for us. And it's never easy for in a court of law, especially when it involves serious offenses and lengthy delays. It's going to take us time, but the court is mindful of the need for an expedition in this matter. She also basically is saying that we'll come up with a decision. But even if we came up with a decision today, we can't just at this point just give you our decision today. We have to give a reason for why we gave the decision that we gave. You understand? So they're going to drag this around a bit longer. And according to the judge, the lead judge, this is where the delay will happen. This is where the delay usually comes in. It is in that period where the decision is being made, given the importance of the case, that the delay will happen. So this is where we're at with this today. So we will have to wait some more, like we've been waiting for years now, and then like we've been waiting since the Privy Council overturned or quashed the original conviction, and we've been waiting and we've been waiting, and I guess we have to wait some more to hear what it is they're going to say. I'll make a prediction. My prediction is that somewhere between, today is the 18th, somewhere between now and the date that that judge gave, my prediction is that they will drag it to as close to July 31st as possible. I don't know, something just tells me that they have somebody else that they have to answer to, and this is not just solely based on them. You know? Now, this is another way of thinking, but I can't help but to think that way. Those judges have somebody else that they are answering to behind the scenes. I think those judges know that the only justifiable thing to do, as hard as it might be for them to do it, is to acquit in this case and throw this whole case out and be done with it and have those guys walk out of there exonerated. But somebody in position of power who is higher than these judges, I believe, right now is putting in their 2 cents, and it's causing a delay. So what I am predicting is, although the judge said that this, their decision will be made sometime before or by July 31st. I think they will drag it as far as they can. Look and see if I'm telling a lie. If we get a verdict from them and the verdict is in early July, then what I said today was not how it worked out. I'm looking for a verdict later in July, closer to the end. Now, mind you, I already know, right, in myself, this is my thoughts, my beliefs, nobody else's, that they already made a decision on what it is the outcome is going to be. All they are doing now is thinking about how to put that to the public. I'll leave it right there. Just repeat to yourself what I just said. At the end, they already know what decision they're going to make. They are now just pondering on how to put it to the public. We keep our fingers crossed, we keep our prayers up, and we hope that the outcome for this will be a full acquittal, because that's the only justice I see in this particular case. Leave your comments in the comment section below. Tell me what you think about this one. Continue the conversation. Keep the fire alive. Keep on paying attention, and I'll catch you on the next video. It's SouFLoTV. I'm out. Peace.